It's 10 o'clock, so good morning everyone and welcome to the Hill Dickinson Spring Real Estate Update 2021. We're delighted that once again over 500 of you have signed up to attend our Spring Updates, and we'll be serving up our usual mix of property related topics. You're all on mute for the duration of the session, but please ask any questions in the Q&A box as we go along, and we'll answer as many of those questions as we can at the end before finishing promptly at 11:30 this morning. Today's session is being recorded, and after the event you'll receive a brief feedback survey from us, and we'd be incredibly grateful if you would please fill that in so that we can continue to improve these events. And completing that questionnaire will unlock access to the recording of the session and a copy of the slide presentation. In terms of our content today, I'll be looking at some recent cases relating to development constraints. Ralph Bullivant from our real estate litigation team will present a landlord and tenant update, and Ruth Wilkinson from our construction team will be speaking about the use of soft landings in the delivery of new and refurbished buildings. But first, here is Rachel Allen from our real estate team with the news.
Good morning. I'm Rachel Allen. I'm a senior associate in our real estate department, and I normally work across our Liverpool and Manchester offices. My slot's called the news at 10:05. And as you can see from our first slide, the first topic I'm going to talk to you about is COVID-19 and some of the consequences of that for the real estate industry. In our autumn seminar, my colleague Tasneem Atia outlined the various protections that business tenants have been afforded during the pandemic period. In particular, landlords can't currently forfeit business tenancies for non-payment of rent. They can't exercise CRA unless much higher levels of rent are owing than usual, and tenants can't be wound up on the basis of statutory demands served since March 2020. Now, Tasneem mentioned that these protections have already been extended more than once, and not long after our autumn webinar, they were extended again until the 31st of March 2021, despite the government saying that this time would definitely be the last time. In the last couple of weeks, the restrictions on forfeiture and CRA have been extended again until the 30th of June 2021, with the CRA limits increasing again on the March and June quarter days. We expect the prohibition on using statutory demands to initiate winding up proceedings will be extended to match. At the moment, it's estimated that there are between £4 and £7 billion of rent arrears that landlords have been unable to enforce during the last year. The estimate depends on your source. I understand the States Gazette had been quite conservative and suggest it's about £4 billion, whereas the British Property Federation have suggested that by the end of the June quarter date, it's likely to be £7.5 billion in just commercial rent arrears. Unless the landlords and tenants have reached an agreement, these arrears won't simply be written off on the 1st of July, or if extended again, a later date. Landlords will suddenly be able to take enforcement action or risk waiving the right to forfeit if they fail to do so. Landlords with defaulting tenants and tenants with arrears need to be conscious of this and have a strategy in place. Of course, the government hopes that landlords and tenants will reach an agreement between them, and last summer published a voluntary code of practice for commercial landlords and tenants. This encourages transparency and collaboration. The most recent announcement says that there will shortly be a call for evidence to assess how this has worked out in practice. Intriguingly, when the protections were extended in December, the government promised in the accompanying press release a review of that outdated commercial landlord and tenant legislation, including Part 2 of the Landlord and Tenant Act 1954. The recent announcement of the latest extension promises that this review will happen later this year, and we wait with interest to see precisely what it will cover. My colleague Ralph Bullivant will talk later about some of the problems that the 1954 Act currently causes in practice. Next topic, stamp duty land tax. Following a lot of media speculation and lobbying from the conveyancing industry, the budget on the 3rd of March extended the SDLT holiday for residential property. The holiday is really a temporary increase in the nil rate band so that no SDLT is payable on residential properties up to £500,000 or on the first £500,000 of more expensive properties, unless of course the 3% surcharge for second homes applies. Buyers can save up to £15,000 at the moment. The holiday has been extended until the 30th of June 2021, and to remove a complete cliff edge when it ends, will have a half holiday for 3 months after. So from the 1st of July, the nil rate band will be £250,000. And then on the 1st of October 2021, the nil rate band reverts to its more usual £125,000. Also on the SDLT front, from the 1st of April 2021, a completely new 2% surcharge will apply where a non-resident individual or company buys residential property. There's some quite complex rules concerning when a buyer is considered to be non-resident, and that charge is on top of the existing 3% surcharge for second homes and company purchases. So an overseas buyer of a second home could be paying a top rate of 17% on consideration above £1.5 million. The situation in Wales is of course different. In Wales, we've had land transaction tax since April 2018, and there's been some recent changes there too. The holiday in Wales took the form of a temporary increase in the nil rate band for residential property to £250,000. That's also been extended till the 30th of June, after which the nil rate band for residential property will revert to its usual £180,000, which you'll note is more generous than the £125,000 for SDLT. Just before Christmas, Wales increased the second home surcharge to 4%, so I suppose we should stop calling it the 3% surcharge. At the same time as increasing the second home surcharge, the nil rate band for non-residential property was increased by a generous 50% from £150,000 to £225,000, both on purchase prices and lease rents. And then in February, the relevant rent was also increased by 50% from £9,000 to £13,500 per annum. Land transaction tax on commercial leases is calculated separately on the rent and on any premium payable for the lease. The relevant rent is the maximum amount of rent that a commercial lease can reserve before losing the benefit of the nil rate band for any premium. The increase means that more commercial leases will be able to claim separate nil rate bands for the premium and the rent. Moving on to value added tax, which I think is nobody's favourite topic. We had the business brief last autumn, Business Brief 12, which requires early termination fees and compensation payments to receive the same VAT treatment as the underlying supply. Although driven by court decisions in very different contexts, particularly mobile phone contracts, this change of policy has obvious parallels in the property context. Think about premiums payable by tenants as a condition of exercising a break clause, or even dilapidations payable at the end of a lease. Most commentators agreed that the new rules caught the break premium but not dilapidations. However, rumours began to circulate that HMRC were keen to bring dilapidations within scope. Following concerns expressed to HMRC, Business Brief 12 was withdrawn in January and we were promised revised guidance making the position clear. That guidance was hoped to be received on the 1st of February and then the 1st of March, and now we simply don't know, although we have heard a mention of September. We understand the delay is to facilitate discussions with the property industry about how to treat dilapidations. In the meantime, HMRC say we can treat early termination fees and compensation payments however we like, either as further consideration for the underlying VATable supply or as outside scope. Really, we should just carry on doing what we've been doing previously. For the time being at least, VAT Notice 742 still confirms that dilapidations payments are outside the scope of VAT. And also my construction colleagues have asked me to just give a quick reminder that the VAT reverse charge came into force on the 1st of March this year. That's tax done. For now, moving on to Electronics Communications Code. At one of these updates a couple of years ago, we looked at some of the early cases on the latest iteration of the Telecoms Code. The new Electronic Communications Code has applied since December 2017. Our last talk concentrated on operators seeking new sites for mobile phone masts, including an early case confirming what we'd all suspected, that mast rents under the new code, valued in a fictional world where mobile phones don't exist, are going to be much lower than they had been before. Attention's now turned to the renewal of telecoms agreements that were put in place under the previous code. Operators are understandably keen to get into the new code terms as soon as possible to take advantage of enhanced rights and lower rents. The code deals with renewal of existing agreements, but requires agreements that are within the Landlord and Tenant Act 1954 to be renewed under that Act rather than under the code. So, an agreement that either falls short of being a lease or which was contracted out of the 1954 Act can be renewed under the code, but leases within the 1954 Act cannot. The fear for operators is that a 1954 Act renewal won't necessarily be as favourable to them, particularly on rent, as a code renewal. There's been two significant cases that clarify the position. Earlier this year, I think it was in January, in Cornerstone Telecommunications Infrastructure and Ashlock Limited and AP Wireless 2 UK Limited, the Court of Appeal confirmed the decision of the upper tribunal that an operator who was occupying under an agreement that was protected by the Landlord and Tenant Act 1954 must renew under that Act, and it can't circumvent that Act by applying for a new agreement under the Code. Late autumn last year, we also had a first case involving a renewal under the 1954 Act. That was Vodafone Limited and Hanover Capital Limited. Although 1954 Act renewals are heard by the County Court, this one was heard by the Upper Tribunal, which hears code cases, sitting as the County Court. But even that didn't help the operator, with the court setting the rent at £5,750 per annum, more than 2.5 times the £2,250,000 per annum rent that the court said would have set under the code valuation basis. Of course, following the renewal, the new agreement is always protected by the code rather than the 1954 Act. So the landowner gets the benefit once, and the next renewal will definitely be under the code and subject to valuation under the code. But this will certainly soften the blow. The government's currently consulting on the Electronic Communications Code and 3 particular areas where it isn't working as the government and the telecoms operators would have liked. First is how to get agreements in place more quickly. Second is the rights for operators to upgrade equipment and share sites. And the third is difficulties with renewal of expired agreements. If you'd like to respond on the consultation, you've not got long. The consultation closes on the 24th of March this year. Moving on to our final slide. Just a quick wrap up of a few points on MEES. Climate change is sure to feature high in global post-pandemic politics, and you might recall that since April 2018, the MEES regime has made it unlawful to grant a lease of substandard property unless an exemption applies. At the moment, a substandard property is one with an EPC rating of F or G, but that's going to change. The government recently consulted on a proposal to raise the minimum acceptable EPC rating for residential properties to a C. That's to apply to new leases and renewal leases from 2025 and to all leases from 2028. We still await the government's response to the consultation on commercial properties, which closed in early 2020, and that proposed to raise the bar for commercial properties to either a B or a C by 2030, either being a single jump in 2030 or by stepped increases between now and then. So we don't know exactly how things will change or when, but anyone who owns or acquires investment property must accept that the MEES regime is going to become stricter and that action may be required to continue to be able to rent out certain properties. That's the end of my presentation. I'm going to hand you over to my colleague Ralph shortly, but if you've got any questions, please do raise them and we'll try and pick them up at the end. Thanks.
Thank you very much, Rachel. Here we go. Right, I'd like to take us now on a short and definitely socially distanced journey to Grazington. Here we are, where Grazington Developments is seeking to assemble a greenfield development site, part from private landowner Grazington Estates and part from Grazington Council. And along the way, Grazington Developments encounter a number of development constraints that have come before the courts in the last few months. Now, it's not uncommon to find references to mines and minerals being accepted and reserved when we look at registered titles, and Grazington Estates title is no exception. So we have here an entry on their title referring to a conveyance dated 10th of May 1980, and if you obtain a copy of that conveyance from the Land Registry, the land was conveyed to Joe and Jane Bloggs, accepting and reserving to the seller all mines, minerals and mineral substances lying beneath the surface of the land transferred at a depth below the lowest level of past excavation carried out by the transferor, but without the right to work or get the said minerals or mineral substances. And that was exactly the position that occurred in this recent case, ARC Aggregates and Branston Properties Limited. In fact, that wording I just read from the conveyance is taken from the conveyance in this case. Now, Whilst we are perhaps more used to thinking that an exception of reservation of mines and minerals reserves a right to a previous owner, akin to an easement or a profit prendre, what ARC argued in this case was that rather than reserving a right, they had actually accepted the land. They had retained freehold ownership of the mineral strata, effectively creating a horizontal title boundary beneath the surface of the land and reserving, in effect, a subterranean ransom strip, which then came into play when Branston started developing the site and digging for their foundations. And that was the question that came before the court. And the court agreed with ARC that what they'd actually done was retaining the freehold ownership in the minerals rather than simply reserving a right. And the appeal to that claim has been dismissed just in the last week or two. Now, if that's right, and that freehold ownership of the mineral strata has been retained, then if you start digging down and encroach into that mineral strata, then you're encroaching into land you don't own. And that's trespass just as much as if you start building on the land next door that you don't own. So Grazington Developments in this case will be requiring some sort of geotechnical survey here to establish what is beneath the surface and at what depth and whether they're likely to interfere with it with their proposed development. They will inevitably require indemnity insurance against the risk of claims and problems with this. And if it turns out that there are mines and minerals, and again, could we look at sand, gravel, depending on the definition of minerals in connection with a particular agreement. If they can't avoid interfering with mines and minerals that are owned by a third party, then they may ultimately have to do a deal. So mines and minerals, something to watch out for. But that's not Grazington Development's only problem with this site. Turning on to the next page of Grazington Estates title, there's a couple of restrictive covenants here, just the sort of thing you don't want to see on land you're planning to develop. So typical restrictive covenants, a no development covenant, no building, structure, erection of whatever nature to be erected on the property, and a very tight use restriction, not to use the property for any purpose other than open space for parking of motor vehicles. So obviously any development of this site is going to be breaching those covenants. So what do Grazington Developments do? Do they seek out the person with the benefit and do a deal with them? Do they apply to court under Section 84 of the Law of Property Act 1925 and argue the covenant should be modified or discharged for impeding a reasonable proposed use of the land? Or do they just crack on and build on the land regardless? Well, that last option is what the developer chose to do in the Alexander Devine case. It got a lot of publicity towards the end of last year. And the developer in that case, and again, those covenants taken on that last year are taken from the judgment in the Alexander Devine case. Those were the covenants that applied here. And in this case, the developer built 13 affordable homes on the land that was subject to the covenant. And then, when threatened with an injunction, they sought a declaration under Section 84, right under Section 84, for the covenant to be modified or discharged on the basis that it prevented a reasonable use of the land and that it would be contrary to public policy to require them to pull down much needed affordable housing. And it's the first Section 84 application that's ever made it up to the Supreme Court. And the Supreme Court said, well, there's been a cynical breach, their words, a cynical breach by the developer of the covenants on the land. But the Supreme Court said that doesn't impact on the decision as to whether the Section 84 criteria have been satisfied. But the cynical nature of the developer's breach did impact on whether the court should exercise its discretion, because ultimately Section 84 is a discretionary remedy. And the Supreme Court said that the developer had effectively created their own argument, created a situation by developing in breach. It's only because they had breached the covenant that the argument about public policy and affordable housing even existed, and that therefore the developer should be denied the exercise of discretion and denied the discharge or modification of the restrictive covenant. So a warning here to developers that restrictive covenants have to be treated seriously, have to be given proper respect. Grazing developers' next issue is about access. Sometimes you're dealing with a development site and it doesn't have the full access it needs from the public highway, and it relies in part or in whole on access over adjoining land. And on the title, if we go back up to the first page of Grazington Estates title, just under the Mines and Minerals entry, we have this entry here. The land has a benefit of following right, a right of way over the blue land, which is the access way, at all times and for all purposes, with or without vehicles. So you look at it, it's a nice wide easement in terms of the wording, for all times, all purposes, with or without vehicles. Surely that's good enough to allow Grazington developments to develop their land and continue to access it over the blue land, which is the main access way to it. The problem we have with easements, however, is that interpreting easements, the court is trying to establish the presumed intention of the parties at the time the original grant was made. They do that obviously by looking at the words of the deed and any qualifications in the wording of the easement, but the words are read in light of the circumstances that were known to the parties at the time of the grant. And so the nature of the access route, the width of the access route, may constrain what you can do with that easement now, just as much as any qualification in the words themselves. There are also frequent disputes in development scenarios where the development is going to result in a change in the nature or the use of the land with the benefit and impose an additional burden on the access way. Remember also that the Section 84 procedure I mentioned, where you can apply to court to discharge or modify restrictive covenants, does not extend to easements. There is no equivalent statutory machinery to allow you to overcome a problematic easement. So if you have a problem with the easement, you're stuck with it. Regular cases before the courts, and simply by way of example, here are 3 cases just from the last few months. First case was Mills. This was a right of way in connection with the use of the land as agricultural land. The land started off as a fairly small scale nursery, but over time the land was developed. There was a retail area, there was a licensed cafe, a substantial car park, and the owner of the land said this goes beyond what was anticipated, what was allowed, and the court agreed. They said that there had been diversification into non-agricultural activity on a significant scale, and this went beyond the scope of the easement. So not a single development where the land simply changed use overnight, but a gradual change in the nature of the business, and eventually they'd gone outside what the easement allowed. McGill was an interesting case, a right of way over an important access road with or without private motor vehicles. The owner of the road said, well, private motor vehicles means private cars. That's all that can use this road. No commercial vehicles at all. It went to court, and the court said, well, we don't think that's what the parties could have intended, because that would have been bonkers, wouldn't it? What about the postman? What about the plumber? So the court assumed that what the parties really meant by that was it could only be used by vehicles which were necessary or consistent with the continued use of the land as a private dwelling. So not necessarily private motor vehicles instead of private cars, but I said your tradesman, the postman, but not construction vehicles. Should you want to extend or redevelop the property, that would take it beyond the scope of the easement. The most recent case was a couple of weeks ago, Bucknell and Alchemy Estates. And you look at the easement in that case, at all times, for all purposes, with or without animals or vehicles, a bit like the Grazington easement we looked at just now. Very widely drafted, but nonetheless, the owner of the access road in that case has been granted an injunction to prevent construction vehicles using that access road in connection with development of the land with the benefit, pending a full trial of the issues. Because it's not a given that even such a wide easement will necessarily allow unrestricted, unfettered access by construction vehicles, particularly, as I say, given the historic nature and width of this particular access road. So even an easement which on paper sounds perfect, may still have physical constraints that prohibit doing what you want to do. So easements, as I said, always difficult to be entirely sure whether it will be sufficient for your purposes, particularly where you are developing the land. Right, well, having resolved all these issues from the title, Grazington Developments go on and they buy the land. You may remember I said at the start they were buying part from Grazington Estates, and that's the title we've looked at. They were also buying part of the land from Grazington Council. So they buy the land, and then they find themselves, having bought it, on the wrong end of judicial review proceedings brought by a disgruntled local resident quoting the Open Spaces Act of 1906. Now, I don't know about you guys, but the Open Spaces Act of 1906 has not particularly been high on my radar until now. So what is this all about? Well, the 1906 Act says that where a local authority acquires land as open space, it holds it in trust to allow and with a view to the enjoyment thereof by the public as an open space within the meaning of this Act. So essentially it's held in trust for public enjoyment. What is open space? Well, Section 20 of the Act defines it as any land, whether enclosed or not, on which there are no buildings or no more than 1/20, so 5% is covered with buildings, and the whole or the remainder is laid out as garden or used for the purposes of recreation, or, importantly, lies waste and unoccupied. Now, if a local authority wishes to dispose of open space, there is a mechanism in the Local Government Act of 1972 that requires the disposal to be advertised in newspapers circulating in the area, and if that procedure is complied with, then the statutory trust is extinguished. The Local Government Act also provides that if that procedure is not complied with, that a buyer from the council still obtains good title to the land. So in our case, this local resident is alleging that Grazington Council did not comply with the statutory process, and the suggestion is that even though the Act says we obtain, or the developer obtains, good title, they obtain good title but still subject to the statutory trust because the statutory trust has not been extinguished. And that is exactly what happened in this case. Day and Shropshire Council. Shrewsbury Town Council had acquired land in the 20s. It had been used as allotments during the Second World War, but in recent years it had just fallen to waste. So wasteland that was sold to a developer. The developer obtained planning permission to develop this land. They were unaware that it was public open space. They were unaware of the statutory trust under the Act. The council, probably also blissfully unaware, did not comply with the statutory requirements, and the complainant Day sought a judicial review of the planning permission on the basis that the planning permission should be quashed because the land is still bound by the statutory trust. And this appeared in the Court of Appeal a month or two ago. The Court of Appeal didn't dwell on the strict literal wording of the Local Government Act, because the strict wording, I think, was problematic for the developer and the council. But instead, the Court of Appeal took a very pragmatic approach, and they ruled that the provisions in the Act that say the buyer obtains good title really means that you obtain good title free from the statutory trust, but only where the buyer has no knowledge of the trust or the failure to comply with the procedural requirements. A quote from the judgment says, in other words, he will take the land without the burden of the Section 10 trust unless he has actual knowledge that the requirements have not been met. So, a case here where ignorance would seem to be bliss. What you don't know doesn't hurt you. But developers still need to beware of anything said in negotiations, anything mentioned in a local search or in replies to pre-contract inquiries that might suggest and put the developer buyer on notice that this is actually public open space. Maybe a tactical decision, But maybe if you are buying open land, even wasteland from a council, it may still be better to ask the question up front and make sure that it's dealt with properly. But in this case, Gresington Developments, being unaware of the existence of the trust on the non-compliance with the procedures, manages to get good title free from the statutory trust. So, having negotiated all these obstacles, Gresington Developments are finally able to commence work on site with their development. And while they get on with that, I'm going to pass over to Ralph to give us his landlord and tenant update. So, thank you.
Thanks very much, Bill. Just trying to move the slides along. Yeah, got to grips with the technology. Right, as you probably mostly know, I'm Ralph Bullivant. I'm a consultant in the property litigation team based in Liverpool. And I'm going to talk to you this morning about a couple of cases arising out of the Landlord and Tenant Act 1954. Listening to Rachel before, she mentioned that it may be that later this year the government will look at the 1954 Act and there may be changes on the way. A wholesale revision of the 1954 Act does beg the question as to what it is that we might talk about on these occasions, as I suspect that a large number of the talks do arise out of some of the difficulties that get thrown up by the 1954 Act, not least some of the issues that we're going to be talking about this morning. Right, I'm fairly long in the teeth and have been doing property litigation for a substantial period of time. And when I first started, we were called article clerks and not trainees. And as an article clerk, my first experience in dealing with the interaction of the 1954 Act and the courts was being sent along to Oxford County Court in order to obtain an order so as to exclude the security of tenure provisions that are provided for within the Act. Of course, what the Act does, it says that if you're a business tenant or premises, you occupy that premises under a lease, then you have security of tenure. When the contractual term comes to an end, the landlord can't require you to vacate unless it's able to prove certain grounds, such as redevelopment, wanting to go into occupation, or breach of covenant. And we'll come on to talk about some of those grounds in the second case I'm going to talk about. And when the Act first came into force in 1954, in fact, there was no ability for the parties to be able to exclude security of tenure. Tenants had it by way of right. But as time went on, it was thought that there were circumstances where a landlord and tenant wanted to agree to exclude the provisions of the Act, and so long as they all knew what they were doing, the law felt, or government felt, that that was okay. So changes were made to the Act in 1969, and a procedure was brought in whereby the landlord and tenant could agree to exclude security of tenure. But to do that, it was necessary to go down to court and to obtain an order from the court, not dissimilar to the one that's on the screen there, an originating summons. This is in fact in relation to possession of property, not exclusion of tenure, but it's exactly the same type of form. And what would happen is that young Ralph Bullivant, as an article clerk, would be given the papers, a cheque for £100, and he'd have to toddle down to the Oxford County Court, get the papers issued, pay over the cheque, and then find a friendly district judge who is prepared to listen to him on a Friday afternoon, hear the representations and make the appropriate order, excluding the security of tenure provisions. And you then have an endorsement on the lease, not dissimilar to the one on the screen, quoting the case number and the date of the order, and the lease would be duly excluded from the 1954 Act. The tenant would not have security of tenure, and when the lease came to an end, the landlord could require the tenant to vacate. That's how the system operated until 2003, by which time every year there are approximately 54,000 odd applications to court to exclude security of tenure. So it's seen as taking up quite a lot of the court's time. Notwithstanding all those £100 cheques that were paid over, the decision was made that there's no need to involve the courts in that process, and so changes were brought into place to exclude the courts in the process and to hopefully make it easier for the parties. Those changes came about as a result of the Regulatory Reform Business Tenancies England and Wales Order 2003, which came into force on the 1st of June 2004. And those of you who were in practice at the time will remember there were all sorts of talks given by lawyers about the changes that came into force at or about that time. To a large extent excluding the courts from the lease renewal process, and also excluding the courts from the process by which leases would be removed from the protection of the Act. And the process, in short, is as follows. If the parties have agreed that the lease is going to be excluded, there's no need anymore to go to court. The landlord serves on the tenant a notice warning that the lease is going to be excluded from the Act and the tenant won't have security of tenure. The tenant, having received that notice, then signs a declaration acknowledging that he's got the notice and that it is aware that the lease will not have security of tenure, and as and when the lease comes to an end, the tenant can be required to vacate and won't have any right to ask for a new lease. In relation to the declaration, of course, what often happens is that things need to be done at the last moment, and if the declaration is going to be signed less than 14 days before the lease is due to be completed, then rather than a simple declaration, the tenant needs to sign a statutory declaration, which means that the tenant needs to find a local friendly solicitor who will take a fee of £5 for signing off the statutory declaration. And that's a system that's operated since 2004. And I think it's fair to say it's a system that's operated reasonably well. Landlords and tenants are well used to the procedure. Transactional lawyers who deal with the procedure on a day-to-day basis are well used to it, and there have been surprisingly few cases that have come before the court in relation to the procedure having gone wrong. I say it's a process that's mostly dealt with by the transactional lawyers in the office. If a query does arise, that's often a query that comes from the landlord, and a question is asked as to whether or not perhaps a step can be either skipped or whether or not a step has been properly followed. And I have to say that if we're advising the landlord, our advice is always that if you want to be sure that the lease is going to be excluded, you need to follow the whole process through exactly as required, so as to avoid the risk of ending up with a tenant that's protected. Which leads us on to the case I'm going to talk about this, well, the first case I'm going to talk about this morning, involving TFS Stores Limited. It was decided back in 2000, at the end of 2019, but it achieved a certain amount of prominence over the course of last year, and I'll come on to talk about that in a second. But TFS Stores Limited are the fragrance shop, which you'll no doubt have heard of and seen either on the high street or in your local shopping centre. They operate small shops up and down the country selling perfume, including a lot of their units are in shopping centres. The case concerned a total of 6 leases, 6 different landlords and 6 properties, including one property not too far down the road from where I live here in Cheshire Oaks. And the case is concerned whether or not the process had been properly followed in relation to the leases that TFS Stores had at these 6 properties being excluded from the 1954 Act. The litigation kicked off with properties at Bridgend and Mansfield, where the tenancies came to an end, and TFS Stores, the tenant, perhaps rather naively expected that although the leases have been excluded from the 1954 Act, the landlord would be more than happy to offer them a new lease. They were somewhat surprised when the leases came to an end, when that didn't happen, and the landlord in fact said, no, we want you to vacate, your tenancies were excluded, you've got no security of tenure, we want you to go. And the TFS Stores were then even more surprised to discover that the reason why the landlord wanted them to vacate was because they wanted to offer the store to a competing perfume seller who was going to pay a higher rent in relation to the units, and the landlord saw as being the better covenant. So TF Stores decided to challenge the position and applied to court for declarations that the 2 leases in relation to the properties they had at Bridgend and Mansfield were in fact protected by the Act because the process whereby the leases were to be excluded had not been properly followed. The landlords in relation to those 2 leases then brought a counterclaim to the court seeking possession, saying that the process had been followed, the leases were excluded and they're entitled to possession. A number of other landlords then caught on to what was happening, and they made applications to court in relation to 4 other leases, where they sought declarations from the court that the leases were properly excluded from the Act, and the TFS stores brought counterclaims to say that they were protected. So there were a total of 6 leases before the court, 6 different landlords, and a number of reasons as to why TFS stores sought to argue that the leases had not been properly excluded. Going through the judgment of His Honour Judge Davis White, it's interesting to see the comments that he makes about the gentleman behind TFS stores, Mr. Vedera. He was very much a hands-on gentleman. It was his company, and he oversaw all that was happening in relation to the company. But it was perhaps slightly naive, and he automatically assumed that landlords would want to grant him new leases, even though the tenancies had been excluded. And it was also apparent that he was looking for any way to be able to find an argument to say that these leases had not been properly excluded. So what were the arguments that were being run? Well, first of all, TFS stores said that their solicitors did not have the appropriate authority to accept service of the notice to say the leases were to be excluded. Now, I said before, the process is that the landlord needs to give notice to the tenant to say the lease is going to be excluded. Although the notice needs to be given to the tenant, in a large majority of transactions that's not convenient, and it's not unusual for the solicitor acting on behalf of the tenant to actually receive the notice, and that's what happened here. The solicitors accepted the notice on behalf of the tenant, but here the tenant said now that because it was the solicitor who'd been served with the notice and not the tenant itself, that meant the process was invalid. Secondly, TFS stores said that the person who'd signed the declarations lacked the necessary authority. So the process is, or should be, that the notice is given to the tenant, and then a declaration is signed. It's either a simple declaration or a static declaration. That's signed by the tenant to say they've received the notice and understand that the lease is to be excluded. And TFS stores said that the person signing those declarations in relation to these 6 tenancies didn't have the appropriate authority. And thirdly, they said there was a discrepancy in relation to the dates, in that the dates upon which it was said that the leases would start and the dates the actual leases did start weren't aligned. There were some ambiguities, and on that basis, TFS stores said that the notices were, the process was invalid. Well, in relation to solicitors lacking authority, the court said that it was clear that the solicitors did have authority. To the extent they were available, the court looked at the court files, the solicitors' files, and the heads of terms, etc., and the other documents that were available. It was clear that these were the solicitors instructed to deal with the transaction on behalf of the tenant, and they represented that they had authority to the landlord solicitors. So on that basis, the court was satisfied that the solicitors had the appropriate authority to accept service of the warning notices. In relation to the person signing the declarations, they were signed off by the tenant's property manager. He was the person who negotiated the terms in relation to the leases. He was named in the heads of terms, and he was the person who had authority from the chief executive to deal with all property matters. The court was also satisfied that the chief executive, Mr. Vedera, knew what was happening in relation to these transactions and knew that the leases were due to be excluded from the 1954 Act, although it may be that he didn't fully understand what the implications of that might be. So the court was satisfied here that the person signing the declarations had the necessary authority, so the tenant failed on that point. As to the discrepancies on the dates, here you've got an example of the declaration that needs to be signed by the tenant to say that it's received the notice. So it says that I, the tenant, propose to enter into a tenancy of the premises at X, give the address of the tenancy for a term commencing on, and then there's a box to put the term commencement date. Of course, what often happens is when the tenant is actually signing off on the notice, the term commencement date is not entirely clear. It's going to happen in some days' time, but the parties may not know when exactly that date is going to be. So in relation to these 6 tenancies, various dates had either been inserted there, or wording had been used to the effect that the date was going to be ascertained at some point in the future, or the term commencement date would be the date on the lease once it had been completed. But here TFS Stores said that wasn't sufficient. The declaration should contain the term commencement date, and in the absence of that, the process was invalid, and the notices were all protected by the leases were all protected by the Act. And I'm pleased to say here you have a rare example of the court showing some good common sense. Mr. Judge Davis White was having none of that, and I think he recognised that if he was to decide in favour of the tenants in relation to this, then up and down the land there would be solicitors going through files going back to 2004, looking at the declarations that had been signed off and identifying the discrepancies in relation to the dates, and it would become apparent that a large majority of the excluded leases that had been entered into between 2004 and now were in fact protected, and there would be complete pandemonium. So in relation to this, the judge said, this seems to be a recipe for confusion, uncertainty, and the frustration of perfectly sensible commercial arrangements entered into between prospective landlords and tenants. It also seems to me a situation where, if this is indeed the position, commercial parties might well with justification say that the law is an ass. I did not consider that this does represent the law. So I'm pleased to say on that basis that the judge decided that the tenant was unsuccessful, the law was not an ass, and these leases were all excluded from the Act, and TFS Stores did not have the protection of the Landlord and Tenant Act 1954. But that's not the end of the matter, and that brings me on to the next slide, which is a picture of an ass, and perhaps certain aspects of the case where the law does not show itself in the best possible light, depending upon whether you're the landlord or the tenant. So there are two other issues that arose from the case. Bill's mentioned that rather obscure bit of legislation involving the public open spaces. This concerned an even more obscure bit of legislation being the Landlord and Tenant Act 1730, which is still on the statute books and does provide that if a tenant willfully holds over once its contractual term has come to an end, then the landlord can require that tenant by giving notice to ask that tenant to pay double value, what's sometimes called double rent in relation to that continuing occupation. Here the landlord said that the tenant knew perfectly well what they were doing in terms of not vacating. Tenant knew perfectly well that these leases were excluded from the Act. As such, they're willfully holding over. So the tenant asked the court to order the tenant be required to pay double value. Perhaps surprisingly, the court said, no, I don't agree with that. The tenant here had very high-powered legal advice. They're being advised by a chap called Guy Featherstone Hawke, who's one of the leading, if not the leading, property barrister in the country. There are arguments to be made out as to whether or not these leases were excluded, and on that basis the court decided that the tenant wasn't willfully holding over and wasn't required to pay double value. I find that slightly difficult to reconcile in circumstances where, on the one hand, the judge said the arguments being made by the tenant, if successful, would show the law as being an ass, but on the other hand, the court was satisfied the tenant wasn't willfully holding over. But be that as it may, the second point that arises out of the case is one that comes as a result of coronavirus. So following the decision in the High Court, the tenants then pursued a claim, an appeal to the Court of Appeal. That was due to be heard last year in June. But the tenant said that you heard what Rachel was talking about in relation to the coronavirus legislation about forfeiture and CRA. One of the effects of that legislation as well is that landlords cannot pursue possession proceedings. And when it came to the Court of Appeal, the tenant said that in effect what the landlord was doing here was seeking possession of these properties, because if the tenant didn't have the protection of the 1954 Act, then the landlord would be entitled to possession, and that indeed was what the landlord was claiming. So the tenant said that the landlord shouldn't be able to pursue the claims with the Court of Appeal, and the cases should be stayed until such time as the stay provided by the coronavirus legislation in June this year is lifted. And the Court of Appeal agreed with that. So although an appeal is pending, It's not yet been determined and won't be determined until such time as a stay on possession proceedings is lifted. So an interesting case in relation to excluding tenancies from the 1954 Act, which brings me on to the next case, which I'm just going to talk about briefly. Before we get onto the case itself, as opposed to a picture of an ass. My slide's not working now. Yeah, we've got a picture of a horse. You've got the chat box, so let me give this as an opportunity for you to be able to name the horse, tell me what it's done, and identify the connection between this horse and the case I'm going to talk about just for a couple of minutes now. The case is Kent and Guest, and this also concerns issues in relation to excluding leases from the Landlord and Tenant Act. Kent were the landlord, Mr. and Mrs. Kent were the landlord, and Mr. Richard Guest was their tenant. The Kents bought a bit of land in Yorkshire near Wetherby, 40 acres of land which comprised of a riding stables. They wished to build a house on the land, and in the meantime they wanted the riding stables to operate, and they employed Mr. Guest to operate the riding stables for a period of 1 year whilst their house on the land was being built. And to put this arrangement into place, they granted a lease to Mr. Guest for a period of 1 year to allow him so he could operate the riding stables. But the lease was going to be excluded from the protection of the 1954 Act, but Mr. and Mrs. Kent got something wrong in relation to that. It's not quite clear what, but it appears they didn't properly follow the notice procedure, as a result of which Mr. Guest had the protection of the Landlord and Tenant Act 1954. So when the tenancy of 1 year came to an end, he wasn't obliged to vacate, and so Mr. and Mrs. Kent had to serve him with a Section 25 notice, and they served him with a hostile Section 25 notice relying upon grounds A and C. Ground A is disrepair, so if there's an obligation of the lease to put the property or keep the property in repair, and the tenant fails to comply with that obligation, then the landlord can seek possession. Ground C is in relation to the breach of other obligations in the lease other than disrepair and the obligation to pay rent. And if there are substantial breaches, and I emphasise the word substantial breaches of those other obligations, then the landlord is entitled to terminate the lease. Mr. and Mrs. Kent said that there were elements of disrepair and there were other breaches of other obligations of the lease. The case went before a recorder, I think in the Leeds County Court, had decided in favour of the tenants, decided in favour of the landlords, and decided that the landlord was entitled to possession and Mr. Guest wasn't entitled to a new lease, and made the appropriate order. Mr. Guest then appealed that to the High Court, and the basis of his appeal basically was that in making his decision, the recorder had failed to make use of the word substantial. Although the recorder was satisfied that there was disrepair and that there were breaches of other obligations in terms of the property being described as being a complete mess, unauthorised use because Mr. Guest was burning waste on the land, and other breaches of covenants within the lease, the recorder hadn't used the word substantial. So on that basis, Mr. Guest said that he should be granted a new lease. But the High Court wasn't having any of that. They clearly weren't particularly sympathetic to Mr. Guest in terms of his evidence. So here, the landlord was successful and Mr. Guest was unsuccessful in terms of his application for a new lease, and will be required to vacate as and when the coronavirus legislation allows him to do so, or allows the landlord to require him to do so. So quite an interesting case to look at if you are looking to oppose the grant of a new lease on the basis of grounds A or C, to one of the more unusual grounds. So that's my talk for the day. I'm going to have a quick look at the chat to see if anyone's got the answer in relation to what the connection was between the picture of the horse and the case I'm just talking about. I can't see that anyone's got the answer, so I'll give it to you now. Mr. Richard Guest was the jockey on that horse. It won the Grand National in 2001, I think it was, and the red horse was called Red Marauder. So there is the connection between that horse and the case. I'm now going to hand you over to Ruth, who I think is going to talk to you about soft landings. So thank you very much.
Thanks, Ralph. I can tell you now there are no horses or asses in my presentation today. So thank you for joining me. And as Ralph said, I'm going to talk to you about soft landings. So my name is Ruth. I'm a construction lawyer, and I draft and negotiate construction contracts and deal with construction disputes. Just if I can get to the slide. There you go. So clients on a new build or refurbishment project are usually focused on getting their construction projects delivered to quality time and on budget. And those clients that own the buildings then hand them over at the end of the construction phase to the facilities manager, who's rarely involved beyond this point, and gives him a bundle of information such as drawings, certificates, etc. from the contractor and design team so they can operate and maintain the building. Sometimes the client passes on the building to an investor or tenant and lets them get on with it, lets them deal with it. If there are any issues or defects in the works, and these are usually the basis of a claim against the contractor or professional team under the terms of the professional contract, or so the building contract, or any collateral warranties. Soft landings is a different approach to dealing with the handover of a building from the contractor to the developer stroke user. And the two key features are, firstly, facilities management is incorporated into the initial brief and followed throughout the period. And secondly, the design team stay involved post-completion for a post-occupancy evaluation period in order to fine-tune and debug systems and ensure occupiers understand their buildings better. The focus on soft landings is to improve the whole life value of the built assets because the cost of maintaining and operating a building is often far more than the cost of construction. So soft landings itself. So soft landings as a concept dates back to 2009 and was created by BISRIA. Now, BISRIA is the Building Services Research and Information Association. It is designed as a cradle to operation project process, which allows the designers and the constructors to focus more on the operational performance outcomes from the outset. This helps deliver buildings that achieve their energy and environmental performance ambitions and focus on the needs of the occupants. It's intended to avoid any bumps between completion and operation, and hence the term a soft landing. The BISRIA Soft Landings Framework was first published in 2009 and most recently updated in 2018. It sets out a series of steps and is intended as guidance, a so-called methodology that can be tailored to each individual project. Soft landings can apply to both new and refurbished projects and to alterations, and also to both private and public sector contracts. It introduces supplemental activities to the construction project process in order to achieve a more performance-driven outcome. It can include success criteria, performance targets, and evaluation methods. In June 2020, the Better Buildings Partnership and BISRIA published a joint report called Soft Landings, the Benefits to Commercial Property Owners. This focused on the property sector's growing ambition and desire to support the transition to net zero carbon. And a good example of the performance gap in buildings is that actual energy performance data tends to have no correlation with the EPC ratings of an office building. So soft landings, so it was adapted in the I've got two screens and my mouse is not going the right way, so I can't get it. There we are. So there we go. So it was adapted in 2011 by the government for the government soft landings. And government soft landings is different to BISRIA soft landing, to the BISRIA soft landings framework, as it's not an integrated and collaborative client stroke delivery team process like BISRIA soft landings, but instead a set of facility management driven requirements for a well-performing building. It contains a set of activities and tasks on project delivery, and these are mostly defined and managed by a GSL, government soft landings client sponsor, and a project GSL champion who could be either appointed by the individual government department or sourced externally. GSL is mandatory for central government projects and has been since 2016 and sits alongside Building Information Modelling, or BIM. Building Information Modelling involves storing and representing information relevant to the construction and future operation of a building in electronic form. A good example of GSL in action is that all school construction projects now use the Department for Education soft landing strategy. Also, many of you will be aware of the Building a Safer Future independent review of building regulations and fire safety, which was published in 2018 after the Grenfell Tower fire in 2017. This report was about high-rise residential buildings and highlighted the concerns that processes that drive compliance with building safety compliance were weak and complex with poor record keeping. The report called for the golden thread of good quality information to be generated so that building owners could get the information that they needed, and there was a clear link between design, construction, operation and maintenance. Many senior people in the construction industry think that soft landings and BIM will help generate this golden thread. Whilst the two frameworks are aligned and there are many similarities, there are some differences as well. In this talk, I'm going to focus on the BISRIA soft landings framework. So how does it work? Well, it requires clients to appoint designers and constructors to stay involved with the building post-practical completion for an initial 3-year post-occupancy evaluation period. This helps the facilities managers and the occupiers to understand how to control and use their building, and, for example, to optimise the operation and maintenance of that built asset. At the end of the 3-year period, the building could be judged against the performance targets that have been set, and any discrepancies can be accounted for. It was designed to assist the construction industry and the clients to build better buildings. And these principles can be applied to environmental targets such as energy efficient ratings and carbon emissions. The soft landings framework is a process that describes the activities, responsibilities and roles over 6 project stages, from inception and briefing to a maximum 3-year period of professional aftercare. It needs to be modified for each individual project through discussion with the project team at the outset and during the project. BISRIA say that soft landings work best when the clients are fully engaged in the process. The client has to lead this process together with the funders and ensure that soft landings is embedded into the project and all the contracts. BISRIA recommends that a soft landings champion is appointed by the client, and there are also soft landing leads on the project side. The client side soft landings champion may in fact be the facilities manager. Ideally, the facilities manager or those responsible for maintaining the building is engaged early on so that a long-term building management plan can be worked out and the FM team has the opportunity to influence the design and specification. So what I've set out on this slide is the 6 phases that are set out in the soft landings framework of 2018. So the soft landings framework is based on this 6-phase approach from inception to completion and beyond, and it's intended to complement the other activities that are being carried out by the design team at this stage. The approach is largely similar to that under the 2009 framework, but also includes post-occupancy evaluation. I'm going to go through each stage very briefly. So the first stage is inception and briefing. This is where the parties should meet in the early stages of the project in order to clarify their respective roles and responsibilities. The parties will define the client requirements. For example, they will set goals for performance and define the success criteria by which the project will be measured. There will also be the instruction of soft landing champion and leads. The second stage is design development. So this is where it includes a specification and part of the construction process. The relevant teams will engage collaboratively in workshops, reviewing the likely performance against the original expectations and ensuring the project can be achieved. The third phase is construction. This is where the facilities manager and end users should be more closely involved in the project and in decisions that affect operation and management of the built asset. The fourth stage is pre-handover. It's intended that there's greater involvement of the designers, the builders, the operators and the commissioning and control specialists in order to strengthen the operational readiness of the building. And the specialists will ensure the facilities team understand the systems and controls for the building in full. The 5th phase is initial aftercare. During this phase, this is kind of a user settling in period. A representative or team from the design team are based on site and are able to pass on knowledge, respond to queries and react to any teething problems. The 6th phase is the extended aftercare and the post-occupancy evaluation period. This involves the periodic monitoring and review of building performance through energy monitoring, fine-tuning and occupant surveys to ensure that the end user and the client are satisfied with the end project. So having given you a bit of a whistle-stop tour of the soft landings framework and explain what it is, what does that mean in terms of the legal and contractual issues that are flagged? So the incorporation of soft landings and the use of the soft landings framework is going to impact on the services that are being provided by everyone involved in the project, including this extended handover period of 3 years. Also at completion to carry out an annual post-occupancy evaluation. There are 6 legal issues that I'm just going to touch on. The first is that soft landings can apply to any type of procurement. It can apply to the traditional form of procurement where the employer and his design team carry out the design work and the contractors engaged to build to that design, or alternatively design and build contracts where the contractor is asked to take on full design responsibility. There are other types of contracts such as alliancing where soft landings might be used. An alliancing contract is a type of partnering contract where the parties work together and collaborate to deliver a project. This is very much aligned with the philosophy of soft landings. Alliancing enables the owner of an asset to take an active involvement in a project, aligns the interests of the members of the project team with those of the project as a whole by way of a pay and gain share mechanism, and encourages the parties to operate in a frank and open manner by requiring them not to sue each other except in very limited circumstances. However, alliance contracts are pretty unusual in practice. Secondly, the soft landings framework is guidance only and sets out process recommendations. The intention is that there should be a workshop at the outset with the design team and the client and the facilities manager to agree how the framework should be incorporated into the project and identify specific duties and client requirements that need to be included in the tender documents. Thirdly, ideally the soft landings framework will apply to all of the project participants, as well as the various phases during construction. Soft landings also requires clients to appoint designers and constructors to stay involved with the new building beyond practical completion for this 3-year post-occupancy evaluation period. It's important that all the project participants, so the design team, the contractor, the subcontractors, etc., sign up to the framework, and that also includes the facilities manager. Early appointment of all the key consultants and identification of their respective soft landing roles and responsibilities is essential, not least because this will help ensure early identification of the project brief and expectations. And of course, this will no doubt attract an additional fee. So the fourth issue relates to practical completion and the defects liability period. So I've mentioned a few times it's an extended post-occupancy evaluation period of 3 years, which is going to extend the involvement of the project team beyond what is usual on a construction project. Usually under a building contract, the contractor remains on the hook to remedy any defects, to return to site to remedy any defects after practical completion for a 6 or 12-month defects liability period. Within building contracts and appointments, consideration needs to be given to the definition of practical completion. Practical completion is not usually defined in the standard form, and it can cause disputes as to whether practical completion, so completion of the works, has been achieved. I often recommend that a definition of practical completion is included in the construction contract, and often that same definition is used in the associated property documents as well. In addition, I also recommend that certain preconditions to practical completion are agreed. If soft landings is incorporated, this could involve the certification of practical completion being conditional on review and approval from the facilities and operation managers, and may be involving testing and commissioning of the M&E system. In addition, with the introduction of a 3-year post-occupancy evaluation period, careful consideration needs to be given to the definition of defects and distinguishing kind of mere performance issues or teething problems. While defects arise from design errors or poor workmanship have distinct remedies under the building contract, the obligations and responsibilities of parties when performance issues arise need to be clarified when soft landings applies. For example, a slight increase in the amount of carbon emitted from a building may qualify as a performance issue as opposed to a defect, and the contracts therefore need to set out in detail which of the parties are obliged to assist with ongoing operational support and fine-tuning of, for example, the air and heating systems. Soft landings aftercare will run alongside the defects warranty period and beyond that. There needs to be care taken that there's no mix-up or overlap with the snagging items, because soft landings is not about fixing things that don't meet the output specification, it's about identifying things that are not defects, shortfalls in performance, in controllability, dealing with unintended consequences of system operation. For example, how the automatic lighting system works, whether the motorised windows are working, etc. This means that the original design team can help the facilities manager and the end user to understand how to control and maintain their building to get the best out of it. Energy use and occupancy satisfaction can be monitored, as well as the operation of systems that might need some seasonal tweaking. And at the end of the 3-year period, the building's performance is judged against the standards that were agreed at the outset. So, time for my summary slide. So the key takeaway for soft landings is that it's designed to ensure that the client gets a better building and to avoid the bumpy handover between construction and operation. It's evident that the use of the soft landings initiatives is gaining in popularity, particularly considering its support from the UK government, been mandatory since 2016 on certain public projects, and it has been used in many public projects, including schools and hospitals. It's also gaining traction on private sector projects, and there's various case studies that you could look at on the BISRIA website and also in the 2020 Soft Landings report for commercial property owners. I mentioned the Building a Safer Future report by Dame Judith Hackett at the outset, and her comments that there needs to be a golden thread for all complex and high-risk buildings so that the original design intent is preserved and recorded, and all changes go through a formal review process, including people who are competent and who understand the key features of the design. Supporters of soft landings think that it, together with BIM, is able to produce that golden thread. Now, soft landings at its heart is intended to be a collaborative process, and this is somewhat at odds with the usual antagonistic stance taken in construction projects and the blame culture. Perhaps for a more widespread take-up, there needs to be a fundamental culture shift in the sector itself. Finally, a question for you. Is soft landings for you and your project? I can't answer that, but hopefully this talk has given you some pause for thought, so you may want to go away and find out a bit more about soft landings. If you want to email me after this talk, I'm more than happy to provide you some of the links to the resources that I mentioned. Thank you very much, and I'll hand over to Bill.
Thank you to Ruth, and thank you to all our speakers this morning. I hope that's given you some food for thought, and there's been something there hopefully for everyone. Before we do the Q&A, I think we owe an apology to Matt Clark of Vale Williams, who did get in with Red Marauder, ridden by Richard Guest. So congratulations, Matt. I'm told the prize is the knowledge that you're the only person that got it right. So hopefully that will put a smile on your face for the rest of the day. If anybody wants to raise any more questions, please do so in the Q&A box. If not, we'll make a start with some of the ones we've got. So the first question we have is for Rachel. It's about SDLT. For individual owners as opposed to businesses, what definition is used for second homes?
Thanks, Bill. So unfortunately, there is no lovely definition that we can point to and say this is it. There's been a case on the matter of second homes which gives some guidance. Let me go to, sorry. Firstly, if you end up owning 2 or more properties and the second property that you are purchasing is not a replacement of your main residence, then the second homes levy will apply. What a second home is and what a main residence is isn't clearly defined, but we have had some guidance, so the courts will look at the facts and all the circumstances in each individual case. They'll look at things like where you're registered with your doctor or dentist, where your car is registered and taxed, what's your main address for council tax, if you have children living with you, where they go to school. It certainly isn't cut and dried. If you have a situation where you have a bit of an overlap from selling your main residence to acquiring to move to where you haven't sold your old residence at the same time as you've acquired your new one and you own them both for a brief period, you can claim relief. So you have to pay that higher rate, and then if you subsequently sell your old house, you can get relief within 3 years, as if you sell within 3 years. And yeah, that's it, basically.
Thank you very much, Rachel. Question then on my talk. I'm asked on the Alexander Devine case, given the failure of the Section 84 application, does that mean these affordable homes will now have to be pulled down? The short answer to that is we don't know. This was simply a Section 84 application, but the Supreme Court has refused to modify or discharge the covenant. The injunction proceedings brought by the cancer charity next door, which has been stayed until the Section 84 application was resolved, will now become live, and there'll be a discussion under that as to whether an injunction is awarded to pull down, or whether there's a settlement, or whether it's dealt with by way of damages in lieu of injunction. So yeah, there's more to come in that one before it comes to an end. Right, just having a look. I think That's what we have at the moment. So in that case, then it's 11:15. As I said, thank you very much, everyone, for joining us this morning. So please complete the feedback survey when you get it. We do use that to plan these events, and particularly sort of the topics that you guys are interested in. And with that survey, you'll get access to the recording and the presentation. So otherwise, thank you very much for joining us. Enjoy the rest of your day. And who knows, maybe by autumn, we'll be allowed to meet up in person again. So thank you very much for joining us, and we'll see you all soon. Thank you very much.